Today we are going to be talking about Rule 410, which states that a prosecutor is not allowed to admit statements made during the plea bargaining process against a defendant in trial for fear that the jury will interpret partaking in a plea bargaining process as an admission of guilt. Much like with a contract, the defendant has the right to withdraw his guilty plea at any point until it is accepted. Once the guilty plea is accepted and finalized, Rule 410 no longer applies. So Rule 410 actually has two exceptions. The first one is that if a defendant admits a statement made by the prosecutor during the plea bargaining process in the trial, the prosecutor might be able to admit something that the defendant said during the plea bargaining process if it requires clarification for the statement to make sense to the jury. The second exception applies only to prosecutions for perjury or a false statement, so long as the statement was made under oath, on the record, and with counsel present. So, I enlisted the help of my three siblings, Ben, Rebecca, and Kimberly, to help me explain the rule to you in a way that's a little bit more entertaining than making you sit here and listen to me drone on and on about it. Without further ado, here they are.
Do you understand why we brought you in this evening?
Yes, I do, but I have information you might find useful.
And what is that?
Hold on. Before I tell you, I want a plea deal. No more than 5 years in prison.
I'll have to talk to the prosecution attorney. That decision is up to her. I'll see what I can do.
So, Rule 410 wouldn't apply in this first scene. You have Ben, the officer, and Rebecca, the defendant. The defendant expresses that she wants to make a plea deal, and the officer says that it's not up to him and he has to check with the prosecuting attorney. Now, Rule 410 only applies to statements made during the plea bargaining process. This would not be a plea bargaining process because the officer is not in a position to make that decision. It's up to the prosecuting attorney. Similarly, the defendant would have to express an objective belief that she was making a plea bargain. Now, the officer told her explicitly that that decision is not up to him, so there's no way any defendant in that position would think that she was making a plea deal. In determining whether or not a conversation between a defendant and a prosecuting attorney is a plea bargain, there are 3 factors you need to look at. The presence of the prosecuting attorney who expresses an intent to make a deal, the presence of the defense attorney so long as the defendant is not pro se, and whether or not the charges have already been filed.
Ms. Palmer, we are inclined to offer you a plea deal for your cooperation. 5 years with possibility of parole after 12 months.
What would be the maximum sentence if I go to trial?
We would seek 15 years. We are willing to give you such a lenient deal because we know that you are not the mastermind behind the crime, and without the influence of your co-defendant, you would not be in this position.
I'll take the deal.
Now in this scene, the defendant Rebecca has her defense attorney, now played by my brother Ben, present with her during this process, and the prosecuting attorney expresses a clear intent to enter into a plea bargain with the defendant. Rule 410 would apply in this situation, given the presence of the prosecuting attorney who expresses an intent, the presence of the defense attorney, and the fact that charges have already been filed. Now, because 410 applies in this scenario, the prosecutor is not allowed to admit any of the defendant's statements if the plea is withdrawn and they proceed to trial. However, if the defendant wants to include the prosecutor's statement that they know that she wasn't the mastermind behind the crime and that's why they're giving her such a lenient sentence, she is allowed. This may open the door for the prosecutor to include some of the defendant's other statements during the plea bargaining process if they believe that the jury requires clarification for the statement to make sense.
Ms. Palmer, before we proceed with the plea bargaining process, I need you to sign this waiver, giving up your right to not have the plea bargaining process used against you should we go to trial.
I don't understand. What if I don't want to waive my rights?
Then we are not inclined to enter into a plea bargain with you.
This scene is incredibly important to take note of. Many jurisdictions enforce this idea that a waiver of rights is required before the prosecution will proceed with plea bargaining. It makes the rule kind of pointless if you think about it. The prosecution refuses to go along with plea bargaining if the defendant doesn't waive their rights to have the statements made during the plea bargaining process entered at trial. So I'm not really sure what the point of Rule 410 is if you include the waiver of rights rule. However, the prosecution is under a lot of pressure to settle these cases through plea bargaining because trials are pricey. So if we have enough defendants hold out during this process, we might be able to make 410 stick.